All right, welcome back. This presentation is the first presentation on Chapter 4 on civil liberties, a very important topic that addresses, again, the sense in which our government is limited in terms of the things that it can do to us, the kinds of things that, we are bearers of rights. And as that, and because of that, that gives us protections. So I'm going to give you a minute to look through. Here are the key topics. This is, again, how the chapter is organized. I'm going to assume that you can read and not read them off for you. And here are the student learning objectives. Likewise, again, these are the things that we hope that once you've read and mastered this material, you ought to be able to manage these skill sets. All right, so jump in. What government does and why it matters. What does the First Amendment's guarantee of freedom of speech really mean? The story in the text talks about a young woman, high school student named Brandy Levy, who basically went on a Twitter rant because she didn't make the varsity cheerleading squad, and so she did that on Twitter or wherever. I think she posted a picture of herself on social media, and the people at the school became aware of the rant on social media and suspended her. So again, that raises some significant questions about again, what are the limits of freedom of speech? So again, on the one hand, let's see, I'm looking for my notes here. On the one hand, the Supreme Court had ruled that students wearing a black armband in protest to the U.S. involvement in Vietnam was protected speech. But on the other hand, the Supreme Court had upheld a suspension of a high school student who displayed a banner, "Bonged Hits for Jesus," while at a 2002 Olympic torch procession that was moving through the town of Juneau, Alaska. So again, there are certain kinds of speech that we're inclined to protect, and we have to recall that until you are the age of 18, you are a sort of ward of your family, and teachers and educators have a right to discipline you and teach you what is acceptable and what is not acceptable speech. So prior Supreme Court rulings were somewhat inconclusive in this case. In 2021, the Supreme Court ruled in favor of Ms. Levy. The court ruled that her rant did not rise to the court's disruptive standard because the student spoke outside the school on her own time. Writing for the majority, Justice Stephen Breyer ruled that off-campus social media speech differs in three critical ways. Parents, not school officials, should regulate off-campus speech. Schools cannot and should not regulate student speech on a 24/7 basis. And schools should protect even unpopular speech because, as Breyer wrote, America's public schools are the nurseries of democracy. So again, First Amendment protections are oftentimes taken for granted. While swearing about failing to make a cheerleading squad may seem trivial, questions about the nature of the right of freedom to expression raises serious questions. So are there circumstances under which government can restrict individuals' freedom of speech, assembly, and so on? So the Bill of Rights originated with opponents of the Constitution. There is, again, an important contrast to be made between civil liberties and civil rights. And in simple terms, the easiest way to understand it is civil liberties are those those protections we have to freedom of speech, freedom of religious belief, and so on, freedom of association. Civil rights presume that certain categories of people have been subject to discrimination and have been therefore harmed by the government and have some claim to a remedy for that. So the Bill of Rights was considered at the Constitutional Convention and rejected. The fear was that attempting to, list out all the different, rights that we have could expose, if they managed to forget something that could be very important. That became a major point of the anti-federalist attack on the ratification of the Constitution. And again, a lack of a Bill of Rights was one of the things that anti-federalists said was its main defect. And so James Madison was one of the people that said, in campaigning for both ratification and for the House of Representatives, that he would turn his hand to creating a Bill of Rights. So these are sort of the main aspects of the Bill of Rights, and again, they are grouped in important ways, right? The First Amendment is clearly very consequential and reflects this broad commitment to freedom of expression, to freedom of belief. The Second, Third, and Fourth Amendments have deal primarily with federalism to some extent, and the sense in which federal officials can't go knocking down doors, they can't deny states the right to form and train a militia. Amendments 5 through 8 deal with the rights of people accused of crimes, and it's important to keep in mind that is a sense in which the framers were attempting to keep the administration of criminal law separate from politics. They did not want to see politics become, because again, the easiest path for a person to win power is to accuse your opponent of criminal wrongdoing. And then the last two amendments, again, reflect this idea. First, the Ninth Amendment is this lawyerly, anything that we haven't listed doesn't necessarily mean that there are not pre-existent rights. Some people have argued that, with regard to the Dobbs decision, that's something that Alito's decision ignores. And then, of course, the 10th Amendment, which, of course, contains the Reserved Powers Clause, which we talked about quite a bit in the last chapter. The 14th Amendment nationalizes the Bill of Rights through a process known as incorporation. So, again, initially, in the early years of the Republic, there was a fundamental question about whether the Bill of Rights restrained only the federal government, or did it apply to the states as well? In the case Barron versus Baltimore in 1833, they basically ruled that the Bill of Rights applied only to the national government. The ratification of the 14th Amendment in 1868 is one of the most important alterations of our Constitution. It fundamentally rewrites the landscape of constitutional law and the relationship between the federal government and the states, and between the federal government and the citizens of the states. So, nevertheless, the Supreme Court largely ignored the plain language of the 14th Amendment for quite some time, almost nearly 100 years. In the early 20th century, the first time the Supreme Court threatened to incorporate a basic right was Gitlow v. United States. The Supreme Court ruled that freedom of speech was among the fundamental personal rights and liberties protected by the Due Process Clause of the 14th Amendment, and that states had to be careful about violating people's rights. The Gitlow case dealt with a dissident speech during World War I. Benjamin Gitlow was a socialist who wrote a pamphlet entitled The Left-Wing Manifesto that predicted the collapse of capitalism and the emergence of a communist world order. He was prosecuted under a New York statute that prohibited criminal anarchy. Clarence Darrow, who was Gitlow's lawyer, argued that Gitlow's writing was analytical in nature and not a call for the overthrow of the United States government. On appeal to the Supreme Court, his conviction was upheld on the rationale that Gitlow's publication violated the bad tendency test, which lifted, it was basically such speech that promoted bad tendency was not protected by the First Amendment. Nevertheless, again, they argued that had he not been a socialist, they likely would have basically said that he was protected. Likewise, in 1931, 6 years later, in Neer versus Minnesota, the court added freedom of the press to those incorporated rights. And again, Neer was a rabble rouser he had a newspaper, and he printed a bunch of crazy, slanderous stuff, libelous stuff against Minnesota's, political leaders. They eventually broke, basically just had enough and arrested him. And on appeal, they basically, the court held that, you actually have to protect freedom of the press. So it's a very important case. Again, when were the Bill of Rights incorporated? Again, the text notes that today all but the Third and Seventh Amendments are fully incorporated. But almost every state voluntarily complies with the Seventh Amendment requirement of jury trials. And of course, the Third Amendment really, even during the Civil War, which is about the only time that the Third Amendment would be relevant, the Third Amendment deals with the quartering of troops in private homes. Both the Union and Northern armies were relatively scrupulous about avoiding just simply bivouacking troops in homes and seizing property. So they were very careful about that. So that ends this slide. When we continue, we will keep up our discussion of civil liberties. I'll see you next time.